All right, good morning, everybody. Last night was basically the floodgates of government overreach, ATF bullcrappery, and a lot of other stuff that came to light. Now, there was good news that came out of yesterday in terms of the brace ban, and I know that it's going to be controversial to call anything in regards to it good news, but we did manage to get some positive feedback in two areas that we're going to touch on. We also got some really interesting news in an update with the forced reset triggers, in which case it's not looking very good or bad. It's just looking weird. So at this point, we're going to touch on the ATF brace ban stuff first, and we're going to go right into the FRT lawsuit that was just filed last night next. And I stayed up late last night, finished reading the whole court case that was submitted, or the documents that were submitted in the lawsuit. So we're gonna touch on that pretty good here in a minute. So first off, ATF brace ban rule. 922R compliancy is no longer a thing in regards to the brace ban amnesty. Basically, what ATF has clarified, and it's going to be released in a document sometime prior to January 30th, January 31st, there will be a clarifying statement in there around 922R that says if your 922R non-compliant firearm has a brace on it and is now considered an SBR, you're legally going to be able to go ahead and file the amnesty registration. The reason for this is kind of where my speculation laid originally. 922R is a maker's violation. It is not a possession violation. You can legally possess a 922R non-compliant firearm and be in the clear without any repercussion. You cannot make a gun knowingly in violation of 922R. Now, the key phrases there are making and knowingly, because if we kind of dissect what happened here, you legally put a brace on it. The manufacturer legally put a brace on it. There was no knowing violation of 922R because we weren't converting a pistol to a rifle, which that is where the violation occurs, is during the creation of a rifle. So what this means is if you have one of the Century Arms Dracos, for instance, and you were able to get it fitted with a triangular brace, you can register it if you choose to go down that path. And you don't have to worry about removing the brace, changing out the trigger group, changing out a handguard, changing out a safety selector, whatever you're going to do to make it to where it's under that 10 parts. They came out and said that under this amnesty registration with the brace ban, you are going to be eligible to register these rifles even though they use more than the 10 allowable imported parts for the creation of said firearm, which is in accordance with 922R. So I know this is kind of a lengthy, and this is, I really hope the audio is coming through good. This is the earliest time I had to get this stuff done. I'm headed to my SOT, grabbing my next can that just got cleared, so we're trying to make the most of our time this morning. Nevertheless, let's move to the next subject, which is further clarification on when you can put a stock on. An actual stock, not a brace stock. So there has been multiple emails to Ask the Experts from independent folks who have wanted to tackle this, and they have all gotten a mix of answers. In fact, it's pretty much split down the middle, which should be in a case where there is no official ruling and it goes both ways. Half has said leave it at the base configuration. The other half has said we don't care. Keep your registration receipt, essentially your draft that gets sent to you and shows that you have submitted. Keep that with you and you can legally possess a SBR, right? And what they say is it's an SBR, so we don't care. Take the brace off, put a stock on it, put for vertical foregrip on it, put a carbine length tube on it. However you want to design that firearm into what's comfortable for you, you're pretty much in the clear to do so. Bearing in mind, that's only half the agents that have said that. So it sounds like it's conclusive with what I received in my interviews with the ATF that basically said it has a lot of interpretation. and it's going to be up to the individual to interpret how they handle that exact situation. So take that with a grain of salt. There is a new FAQ coming from the ATF, and I believe this question is going to be addressed because a lot of people have reached out about it. The last update is kind of around the Form 20. Another Ask the Expert email stated that you can file a Form 20 with the serial number and it may still go through. I might try this because I work in a different state. I need to file Form 20s from SBRs anyway. So for the year, I'll go ahead and submit a Form 20 with my braced gun and see if it goes through. And then I can give you a real world feedback of whether or not it was allowable. For now, I'd still handle this one with a grain of salt. And if you do travel across states, or if you travel to a state that doesn't allow SBR ownership, you may want to reconsider thinking about filing an amnesty registration and start looking towards the grounds of removing the brace, getting a more comfortable buffer tube, something that is more of a compliance and going to give you less of a headache in the grand picture of things. So now that we've talked about those few updates, again, in my opinion, those were two really good updates, and then just kind of a net neutral here. The last thing that we want to talk about is the FRT, because remember, my channel was designated around FRT. I love FRT. It's such a cool technology. I am a nerd when it comes to innovation, technology, advances in our country and things like that. And so the FRT was always exciting to me because it's like this, they perfected the TACOM 3MR. They kind of used the technology that would exist in a bump stock and a trigger, and it was really cool and it worked really, really well as long as you met certain criteria. So the ATF is suing rare breed triggers, and this is a suit in the civil courts, not in criminal court. And that's important to distinguish because this doesn't mean that they have a strong enough case to go after Lawrence DeMonico from a criminal ground. Like, they're not trying to arrest Lauren. They're not trying to arrest, Lawrence. They're not trying to arrest Lawrence. They're not trying to arrest Kevin. They are simply trying to get the tax money from them because they're a tax agency. And so this lawsuit does a whole lot of wording around what they believe they've committed, which is fraud. So in this civil case, they are suing rare breed triggers based out of the Florida location, and they're suing them in New York. That's important information to know as well, for multiple violations, including consumer fraud, mail fraud, tax fraud, and a couple other things. But those are the three that we want to kind of touch on real quick. So just to give the clarification of each one, let's start with the tax fraud. So when an SOT, that is a manufacturer 0207, is creating or making a NFA item or a GCA NFA item, they have to pay what's essentially called a maker's tax. The same thing you and I would pay if we do a Form 1. They have to pay a $200 tax for each item that they manufactured. Then, in the process of transferring said made NFA items, you pay a transfer tax, which again is $200. And so your sum total on an NFA item is generally about $400 owed between all different taxes that are paid. So they looked at their books and essentially decided that there are tens of thousands of these things out there, and they put a number on it. I don't remember the exact number. I think, but they were pretty close to my estimation back in the day, and it may have been from one of my videos, but I think it's currently down. But Rare Breed was essentially selling out of 350 triggers per day for almost 3 months. So they extrapolated the math. They looked at what the taxes owed would be and basically said they're evading around, what was it, 36 million in taxes owed in back taxes. And so the fact that they were unable to pay for these taxes, or didn't pay for these taxes, because again, they are not SOTs, they are not manufacturers, they are simply making a trigger, an accessory. And ATF has said we do not regulate accessories, but this particular accessory they're trying to regulate because they're claiming that it's still a machine gun, right? So we're going to touch on that more in a second. So the fraud case is basically tax fraud, saying you owe us $36 million in back taxes, and that doesn't include the penalties and the fees and the interest and everything else that we're going to throw at you because you did this knowingly, and that's knowingly doing tax fraud. So that's one. Two, they used in recent times, they used a different company name on their USPS account in order to ship the WOTs that, and this one I'm a little bit questionable about because it was an interesting situation. So back when we looked at how they were selling WOTs again, the ATF had sent out a letter that basically said some FRTs are considered machine guns. And the key part is that it was some and not defined as which FRTs were actually considered machine guns. And so when we considered that, the WOT was never actually listed as one of the FRTs that were included in this. And there was no direct link that read back that said the WOT is a copy of the FRT-15. So again, there was no indication that it was at that point in time considered a machine gun, at least to the general public and what was being put out there. And that's another part of the consumer fraud coming up. But nevertheless, the mail fraud happened due to the fact that they were shipping non-discrete, non-labeled machine guns through USPS, and they were using a shell account to do so. I don't remember what it was called, but it was something like Red Breed something. It still said RBT on it, but it was just three weird words. It kind of sounded like a chicken farm or something. It was interesting. But we're not going to go into any of that too far. So because they were shipping quote-unquote machine guns through the USPS system, and they were non-labeled, they were hiding that they were shipping dangerous materials. That is where the mail fraud comes into play. And then the last one is consumer fraud, because they marketed this item and preached this item to be legal where ATF had already decided it was illegal. And this one is a little bit complex in that it relies on two different parts. The first part was the original trigger that was submitted to the ATF by the parent company that actually made it, which was Alamo trigger guy, Graves, when he actually had the original design. So they created this trigger that was called the AR1. The AR1 was the original prototype for an FRT, but it was a little bit more complex. It had more parts. It wasn't a drop-in trigger, and apparently you couldn't even use a regular BCG. You had to mill out a BCG that was going to interact with the trigger itself, and there was a lot going on, and I'm guessing that the way at which they had it originally designed, it functioned a lot closer to a drop-in auto-sear and became more of, that's a machine gun, buddy. So that's what happened. They sent that to the ATF and said, hey, classify this for us because we want to be able to sell this trigger. We want to be able to patent it. ATF sent them back and said, sir, that's a machine gun. You can't sell that. So they changed the design up a little bit, packaged into a single drop-in trigger, and they filed what was called the 223 patent. That 223 patent was then purchased by Rare Breed. It was then sold to another company, which then Rare Breed would pay a licensing fee per trigger to the parent company that bought the 223 patent from them. I know all that was probably for tax reasons. It was probably for a lot of things, including keeping legal waters down in case all this stuff came up, which here we are. But nevertheless, ATF is using this as justification to say that Rare Breed skirted process by not actually sending a final copy of the 223 patent trigger to the ATF for a decision. Instead, they used a third-party private consultant who was former ATF and, mind you, wrote the handbook for this stuff. And he told Rare Breed, not a machine gun. You are A-OK. And so, based on that information, Lawrence was always pushing in this and saying, these are legal, guys. This is what ATF is saying. And so by doing so, it, of course, increased his sales because it kind of kept people from being afraid of any kind of repercussions for it, right? And so this is where the consumer fraud really came into play, and that was one of the final points. So what the DOG, the DOJ, whatever, what the Department of Justice, United States v. Rare Breed is actually trying to accomplish in this is they want to sue for civil penalties for tax that's been owed, back taxes, interest on the back taxes. They want to do a injunction that stops them from any type of manufacturing, that stops them from any type of sales. They want to force them to release customer records, which won't happen because they're, one, sealed and destroyed to a point, I think. I don't know, I think that was part of how they did their culling of records in a certain time period. But secondly, it's mainly because these records were kept in the lawyer's office since it was co-ran by an actual attorney. And that was the important part, because they were making sure to protect the consumer. But nevertheless, the customer list is being requested, and they were requesting that Rare Breed Triggers not only release that customer list, but they independently, on their own, reach out to all the tens of thousands of customers and tell them that they are in possession of an NFA item and they must return it to Rare Breed. So it's their responsibility to pay postage and collect all these Rare Breeds and then issue refunds for the triggers in which they've already sold. And again, this is all what the court case is arguing in their final page. It says, this is what we want you to do to make this right. This is how you're going to correct this. Nowhere does it talk about criminal charges, because again, this is a civil case here, but nowhere does it talk about the criminal charges, because wouldn't the manufacturing and distribution of machine guns be more of a criminal effort that they need to tackle first? You would go to criminal court first, and then you would go to civil. But they skip the whole criminal proceedings and go straight to civil, because they themselves even know that the argument that it's a machine gun is going to not pass the sniff test. They're still using the verbiage that was basically thrown out when we considered the bump stock ruling in the Fifth Circuit, which is why that court case became such an incredible moment in the Cargill v. ATF, I guess it is, or Cargill v. United States. But nevertheless, Michael Cargill's case with the bump stock was instrumental in getting that verbiage corrected. When it talks about function versus pull of the trigger and the mechanism and how they define that, that is going to be instrumental, and Lawrence is aware of that, I'm sure. There's a great podcast out there with Lawrence and Michael, and they talked about it back and forth a little bit, and it's really worth a playthrough if you haven't listened to it. But nevertheless, their entire civil case hinges on the fact that the FRT is classified and was classified as a machine gun before it even went into production. And they are focusing on that almost in passing. And my honest opinion of this is they are doing that because, one, they know they would lose the case on the machine gun. Two, if they win the case in the civil, they're going to win it on the grounds that it is a machine gun, which is going to set the precedence up for the criminal trial to come after. And that may give them some kind of leverage, but again, they're going to lose it in the appeal. We've already seen this. So either ATF truly feels they can win this case, or ATF has lost its mind and they're honestly just trying to play a money game with Lawrence and Rare Breed and see if they can make their lawyers run out of money first. Which, you know, the United States is already in like trillions and trillions and trillions and trillions of dollars in debt, so what's a couple more billions in legal fees to fight little Lawrence and the FRT community? So guys, that is the Rare Breed updates. I really hope the audio came through good. This was a very long video. I'm wearing a lapel in the car. Again, I apologize if there's some background noise. I do hope that I spoke clearly enough for y'all. If you have further questions, let me know in the comments. If you want any clarification on anything that I said, again, let me know in the comments. I can post screenshots, which I did last night. As I was reading it, I was posting screenshots up on the YouTube channel here in the little post sections. But guys, do just let me know, and we'll try to get back with y'all as soon as I can. The ATF interview video, if you guys watch that, there's a lot of comments I haven't been able to respond to, and I apologize. You know, it's just, it has blown up with a lot of information out there, and it's tired of sorting through all the you're a Fed. Okay, go check out my other channel stuff. Look, you can call me a Fed, but go check out my other stuff and see. But I know it's just an insult in this time of day because, you know, I call one of my good friends a Fed all the time. But he is a police officer, so technically he kind of is a Fed boy. glows at night. Anyways, guys, I appreciate the likes, the comments. They help the algorithm, they help get the message out. We are getting our clarifying questions for the ATF readied up. We are going to wait for the 30th, 31st window. That is when the new FAQ is going to be out. That is when the brace rule will actually go into effect. It's going to hit the registry, we believe, on the 30th. As of right now, the 31st, if not the 30th. When that happens, they will be releasing a new FAQ. A lot of the questions that I asked for clarifying questions, a lot of folks have asked as well. So it's not just my own mindset that's thought of this. So we're going to see what they say in their FAQ. And with that new FAQ, we're then going to go ahead and push to our team's interview and start getting some more clarifying questions if needed. So guys, like, subscribe, comments. It helps the algorithm, gets the word out, and helps keep a lot of people from becoming felons unknowingly. I hope this has been a very clear and educational video. That is the style that this is supposed to be. I know this is not entertaining. You can be listening to this while you drive, doing housework, cleaning toilets. I don't care. But I just want you guys to have the best information possible. I'm not trying to fearmonger anyone. I'm not telling you to go cut up your rare breed triggers, your WOTs, your Tommy Graves. I'm not telling you to do any of that. I'm just saying be informed. Know what you're getting into. Know what the repercussions are. Know what legal battles are currently happening. Know what the definitions currently state. And with that, we'll catch you next time. Thanks, guys.